Hello, everyone. Welcome to a civil rights case from start to finish. I'm Julie Herrera. I'm an attorney in Chicago, and I practice broadly in the area of civil rights. So that's basically, for me, half employment law and half cases against the police. Today, what I'm going to be sharing with you is my expertise when it comes to police misconduct cases. The view or the idea today is to give everyone a broad overview of a civil rights case, how to do it in a very general way. My hope is to share a little bit of information enough so that you know what to look for, what to be on guard against, what to be aware of. And so what I do is I represent people against police officers. And I've been doing it for about 12 years now. It was a passion of mine when I was in law school, and I felt lucky to be able to practice in this area. So I'm really happy to be able to share some information with you all today. And so I think it's important to start with the history of this sort of litigation. So 6 years after the end of the Civil War, Congress passed the Ku Klux Klan Act of 1871 in response to the Black Codes enacted by Southern states during Reconstruction. The first section of that act, codified today at 42 U.S.C. 1983, provides a federal remedy for persons whose constitutional rights have been violated by state officials. So what you will hear is people commonly refer to these cases as 1983 cases. You may have heard that before. It's a common parlance that we use. But as you'll be seeing today, 1983 is not the only cause of action, but it is where we will begin. I think it's always important to look at the statute itself. Too often as attorneys, we immediately start getting into the weeds, looking at the exceptions. I think it's important to start with the statute itself. So Section 1983 says this: every person who under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. If you aren't familiar, an action at law means suing for money damages. So under 1983 cases, what you are doing is suing police officers and or municipalities for money damages. The statute was interpreted to allow lawsuits against police officers only in 1961 in Monroe v. Pape. So 1983 litigation is relatively young, as opposed to, for example, personal injury, contract disputes, or criminal defense. You can find case law in those areas back hundreds of years. Section 1983 litigation is new, fairly new in terms of the law. So the outline of what we're going to be going over today is we're going to be looking at who are the parties in the litigation. What are the causes of action? What are common defenses? Where should you file, state or federal? Statutes of limitation, discovery, summary judgment, trial, and remedies. So we have a lot to cover. So to begin, the first question in civil litigation is who can be a plaintiff? And here, any person who has had their rights violated by the police can be a plaintiff. If you recall the language of the statute, it mentions citizens, but it also says anyone else within the jurisdiction thereof. And so a person who is not a citizen of the United States can bring a 1983 case as well. Whether they should do that and whether that's wise is a separate question. But anyone who has had their rights violated can sue. So that's the plaintiff. The next question in civil litigation is, who are the defendants? The defendants can be individual police officers, and most often they are. How do you find out who they are? A lot of times we get phone calls from people and they do not know the names of the police officers who arrested them. Sometimes officers try to make it difficult for people to know who they are when they arrest them. So we always use FOIA to try to find the identities of police officers. I really enjoy using FOIA, and you can get a lot of information that way. If for some reason that doesn't work, one method is to sue the employer, so like the city of Chicago, and use discovery to figure out who the officer is. The other possible defendants are cities and counties, towns and villages. For state law claims, which we'll talk about in more detail, you can name the officer's employer as a matter of respondeat superior. For constitutional claims, you cannot do that. For constitutional claims, you can only sue the municipality if you can prove that there was a policy in place. And that came from Monell v. Department of Social Services. I cited that. That's also in the materials. There is a wide variety of litigation about Monell claims and what kinds you can have, which is beyond the scope of what we're doing today. But it's just important to remember that if you want to sue a police officer under 1983, you can't automatically sue the city. You need to be able to prove some sort of policy or include a state law claim. So you have your plaintiff and you have your defendant or defendants. And the next question is, what are the causes of action to consider? There are, first of all, constitutional claims pursuant to Section 1983, but there are also state law torts like false imprisonment or battery to consider. What you cannot sue over is negligence or accidents. So we get a lot of these calls, you know, it was a mistake, they had the wrong person, they got something mixed up. You cannot sue over negligence or accidents. But you can sue over intentional behavior. You often want to make both sorts of claims. And so if you take a look at this, constitutional claims, there's often an accompanying tort or a similar tort. So for example, unreasonable seizure under the Fourth Amendment, you can also plead a state law tort of false imprisonment. If you want to make a constitutional claim of excessive force, you can often sue for battery as well. If you want to sue for unreasonable search of the home, you can often sue for trespass as well. And if you want to sue for something like in federal court, what we call a continuing seizure, most people call it a prosecution, wrongful prosecution. Under state law in Illinois, that's called malicious prosecution. Sometimes you can plead both. Sometimes you can only plead one or the other. But it's important to think about both your federal and your state law causes of action that you might have. So I want to begin by talking about the constitutional claims, because this is the thrust of most litigation against the police. And we're going to go in order here of the amendments. So first of all, we have the First Amendment. And the First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for redress of grievances. So in the context of police officers, where you might see this happen is a person protesting outside a police station with a sign that is not polite, you know, that might be full-blown offensive towards the police. And the police arrest the person for carrying that sign outside the police station. That's probably a false arrest. You have freedom of speech and the arrest would probably be illegal. Where this gets very complicated is, you know, where does the speech happen? If it happens on private property, it's a lot more complicated. But when it's happening out in public, often you will have a First Amendment claim for it. So that's the First Amendment. The next major source of 1983 cases is the Fourth Amendment. And I would say that the majority of 1983 cases are filed under the Fourth Amendment. What does the Fourth Amendment say? The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. From these fairly brief words, we have many actual sources of rights under the Fourth Amendment. So let's look at some examples. I like to think about the Fourth Amendment in terms of where a person is, you know, at the time that they believe their rights have been violated, because it matters quite a bit. So starting with on the street, for example, you know, if a man is stopped on the street and frisked and has done nothing suspicious, you can make a claim for unlawful detention. This area of the law is, I would say, one of the most common things to happen factually. It's also, I think, a very difficult legal claim. There's a lot of case law about when a police officer has reasonable suspicion to stop and question a person. As we'll talk about a little bit more later, the courts give a lot of deference to police officers in these situations. They let police officers make judgments based on the neighborhood that they're in. You know, which some people would say is fair, some would say is not. But that's kind of where we start to see the Fourth Amendment violations is just on the street, a stop. So from there, false arrest. So this is one of the most commonly known Fourth Amendment violations, a false arrest, someone being arrested even though they hadn't done anything illegal. Real world examples of this are, someone is taken into custody and arrested because he shook another person's hand on a street corner, and the police assume or believe that that was a drug transaction. Sometimes, of course, maybe they're right, but other times they're not right, and the person was just shaking the hand of another person on the street. That's false arrest. Excessive force, again, a very common, I would say very commonly known cause of action, excessive force. And so examples of this are, a man being put in a chokehold despite not resisting arrest. He's talking to the police, maybe he's verbally arguing, and the police decide to use a chokehold or, to take him down, as they call it, or use some other excessive force they didn't need to use, force that was unreasonable. Other examples of excessive force go so far as, being shot and murdered. Philando Castile. Many people would argue he was shot for no reason at all. And that was basically kind of the worst excessive force that can occur. His family did sue. I didn't include any of those cases in the materials, but that might be a fun one for you to follow up on. His family did sue and the case settled. So moving on from the street, of course, there's a lot of Fourth Amendment violations that occur in vehicles. I would say those are some of the hardest cases to win, to prove and win, because police officers' rights with regard to moving vehicles are very broad. And that's like an entirely different section of 1983 litigation, is what can police officers do with regard to vehicles. But moving on from this street, the Fourth Amendment continues into police custody. So we have seen people who go to police lockup, and the police, while they're there booking them, take money from them, for no reason at all, don't document it, obviously. That's an unreasonable seizure. The police officers did not have the right to seize the person's property. Another example is a person being in police lockup and needing medical attention. So the Fourth Amendment protects a person's rights when they're in police custody they have a right to medical attention, reasonable medical attention. The case law here recently has moved in favor of arrestees, which I was very happy about, to say that the denial of medical care in police lockup, for example, is judged by a reasonableness standard, which is very low. And so, for example, if someone needs an inhaler and it's, somebody's even in their belongings, or their mom has it out front, or their girlfriend has it out front, and the police just decide not to give it to them, that's unreasonable. You can sue over that. So moving on from the street, police custody, another, I think, really fun area is Fourth Amendment violations that occur in a person's home. So examples, the police enter the home without a warrant, without consent, and without an emergency. That's very likely going to be an unreasonable search. Also, you can probably sue for unreasonable seizure of the occupants. Usually people are detained for hours at a time during one of these home searches. But the three things to look for in a case like that are, was there a warrant? Often people will call and say, well, the police didn't have a warrant. Well, maybe the police didn't show it to the occupants, but maybe they did have one. And again, you can FOIA that information and get that. The next thing to look at is, was there consent? So, obviously most people don't want the police in their homes. Of course, there's exceptions to that. But some people give consent when they don't really want to give consent. I think most of the time, as long as the person verbally gave consent, courts are going to say you gave consent, the police could come in. And so that can be kind of a ripe area, factually speaking, when you're looking at these cases, is really getting the client to tell you exactly what was said between them and the police before the police came in. Now, of course, often the police conduct these raids in the middle of the night, do not give warning or give 1 second of warning before busting a door down. That can be an unreasonable search if they had no reason to do it that way. And then finally, emergencies. So most people, I think, would agree that there should be an exception for the police in these circumstances. So for example, if a woman calls 911, she and a man are screaming in the background and then she hangs up. Well, most 911 centers are going to send the police to the location if that happens. If the police officers show up at the door and through the door, they can hear the woman screaming or getting beaten or someone getting beaten or something happened, the police have the right to go in. That's going to be considered an emergency situation. We call that exigent circumstances. Under the law, it really just means an emergency. Another one that I think should be pursued more often than it is the nature of the seizure itself in these situations. So you might have seen some of these news stories where the police come in and bust down a family's door and they're pointing guns at children and old people. I know that there have been a few cases of these in the news. This happens all the time. I hear this complaint all the time. And I think those cases should be brought. You know, if the police officers come in and they point guns at children, I would sue over that any day, and I have. I think they can be fun cases to do. Okay, so that wraps up the Fourth Amendment. There's a lot more to the Fourth Amendment in terms of your rights. I've included some of those cases in the materials. The Manuel case that I included is a fairly recent decision that talks about Fourth Amendment rights in terms of a continuing seizure. So a person that's held in pretrial detention. Those can be, those are rich source of claims. They're very complicated, which is why I'm not getting into it today. It could be a whole CLE itself, hours long CLE for that one. But that's a general overview of the Fourth Amendment rights. So now moving on to the Fifth Amendment. What does the Fifth Amendment say? No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. The Fifth Amendment is actually not such a rich source of 1983 litigation. There's a common misunderstanding that you can sue the police if they don't give you a Miranda warning. That's not correct. So we get those calls very often. Among other things, people report that the officer didn't read me my rights. And people tend to, I think because it's so well known in popular culture, people tend to believe that this is a right that they have. And in terms of the criminal context, which I will not speak to because I'm not a criminal defense attorney, the import is different. So the result, if the police officers don't give Miranda warnings, is different. In the civil context, in a 1983 case, you can't sue for that alone. So you cannot sue because the police officers failed to give you your Miranda warnings. You just can't do that. What you can do, and we're going to get into this in the 14th Amendment, is sue based on what happened after they didn't give the Miranda warnings. You know, did you give a confession that was coerced? And so this takes us to the 14th Amendment. Under the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The 14th Amendment overruled Dred v. Scott, one of the most famous Supreme Court decisions of all time, which had been decided just 11 years before, which had held the Constitution of the United States recognizes slaves as property and pledges the federal government to protect it. And Congress cannot exercise any more authority over property of that description than it may constitutionally exercise over property of any other kind. And so we 1983 lawyers are big fans of the 14th Amendment. The 14th Amendment says, right after the first part I just read, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So what does that mean? The 14th Amendment, again, similar to the 4th, is a rich source of 1983 rights. The Due Process Clause of the 14th Amendment forbids the admission of an involuntary confession in evidence in a criminal prosecution. So an example here is the Brendan Dassey case. So I included this in the materials. I think it's interesting. It's also a pretty thorough analysis of what a coerced confession means. Now, Brendan Dassey, I had to look this up. I hadn't looked at it in quite a while. The Supreme Court declined to hear his case. So Brendan Dassey, there's very little left that he can do. He's still in custody. His conviction still stands. If his conviction were overturned, he could try to sue based on the coerced confession. He currently can't sue because of heck, which we'll talk about later. But the question then becomes, if someone confesses to a crime, can you prove that it was involuntary or coerced? And so normally the way this would have to play out is a person is held in custody for a long period of time based on a coerced confession and then finally let go. When that happens, once the charges are thrown out, at that point, you could sue for a coerced confession. Similarly, like someone like Brendan Dassey, if his conviction ever is overturned, he could then try to sue for the police having coerced his confession. And the things that courts look at are, what you might think physical coercion, the John Burge cases are a rich source of 1983 cases here in Chicago. So that's, physical coercion, actually beating someone into confessing. But there's also mental coercion. So aggressive questioning of a person with a very low IQ, for example, or courts look at the condition of the person being interrogated, their age, their IQ, what could you expect them to withstand? There's a lot of interesting discussion about this in the Brendan Dassey case, so that's why I included it in the materials. The other clause of the 14th Amendment that gets a lot of play in 1983 cases is equal protection. And so again, equal protection cases under the 14th Amendment could be their own CLE. We don't have too much time to get into it, but a very common example we see is, for example, a Black person walks down the street and shakes a friend's hand. A white teenager does that in a different neighborhood. Who gets arrested? Oh, well, we all know the white teenager doesn't get arrested for that, but I have seen many times the Black teenager does get arrested for that or gets questioned for that. And maybe they get stopped and they get frisked, and maybe they have a small amount of marijuana on them when it happens. That can lead to them being in custody and not for a short period of time. So equal protection cases are, I would say a very fun one to litigate, very worthy cause. They can be very difficult. I think courts, especially here in this district, I think it's that they don't want to believe it. And so they've erected some pretty high bars to prove equal protection denial. Okay, so that wraps up my short intro into the various amendments that you can look to for constitutional rights. And so now what I want to talk about are common defenses to anticipate. So, before you file suit, who you're representing, who the plaintiff is, who you're suing, and your causes of action. But it's very important to think about what defenses you might face. You don't want to waste your time filing a suit and get your client's hopes up if there's some major roadblock in your way. So the Heck bar is what I referenced earlier. This comes from Heck v. Humphrey. I think I included this in the materials. And basically what it means is that if a 1983 judgment would render a criminal conviction invalid, the claim cannot proceed. So therefore, if you have been convicted of a crime, you cannot sue over the validity of that conviction. You cannot collaterally attack it, is the word that the courts use. So for example, if someone calls you and says, I was arrested, they claimed that I beat the officer up or hit him, but I didn't, but I pled to that. I pled to it because I wanted to get out. Can I sue them for that now? No, probably you cannot. There's a lot of variance here. You have to look at what the person was convicted of exactly, and often people do not know. And so you often need to look at the criminal documents, talk to the criminal attorney. What exactly were they convicted of? If somebody pled to reckless conduct, for example, but they were charged with assault on a police officer, you could still probably sue for malicious prosecution because they did not plead to attacking a police officer, they pled to something different. So you have to look at the specifics of what they were convicted of and then what you want to sue for. Heck does not bar excessive force cases. So if there is an incident that occurs and someone does plead to a crime, you likely cannot sue for false arrest, but you can still sue for excessive force. So that's an important thing to remember. The next most common defense is qualified immunity. So this means that an officer can be liable only if they violate rights that are clearly established in light of existing case law. This is a huge bar to 1983 litigation. And so I was surprised to find, where does this come from? And it was invented by the Supreme Court in 1967 in Pearson v. Ray. A recent case that discussed it was Ashcroft v. Al-Kid, in which Scalia, a supposed originalist, wrote, existing precedent must have placed the statutory or constitutional question beyond debate. Qualified immunity can be a big, big problem. And with the current makeup of the Supreme Court, I think it's an incredibly big roadblock for plaintiffs. I included one such case in your materials for you to read. Qualified immunity is something that you have to think about from the start because it's going to be raised. So you need to be ready for it. Okay, so that's a federal case, the overview of the claims in a federal case. So as I mentioned before, you always want to think about what state law torts you might have as well. And so some common examples are false imprisonment, malicious prosecution, battery, false arrest, conversion, stealing, trespass, invasion of privacy by intrusion upon seclusion. You want to see, and you want to allege any tort, that you can. Most of these are self-explanatory. The one I included at the end comes from a case that we had where a person, so this is invasion of privacy by intrusion upon seclusion. We had a female who was arrested, and when she was in police custody, she showed the police officers her phone, actually gave them her phone. It was to disprove something that was being claimed about her, I think in terms of maybe threats she had made against a person, a number of calls she had made, something like that. And the police officer, when he had her phone out of her sight, he opened up her photos, found nude photos, and forwarded them to himself, to his personal cell phone, which she only found out a couple days later when she was looking at her sent messages. We pled that tort, and the reason we pled that tort is because there was some bad case law about qualified immunity. Judge Holderman, who at the time was the chief judge of the Northern District of Illinois, found that the police officer in that situation was entitled to qualified immunity because there's no clear case law saying that you can't take an arrestee's phone and forward things from it to yourself. Which I think was a very bizarre decision, but one we weren't surprised by, which is why we pled this state law tort as well. And so sometimes you need to cover your bases. If you have a federal claim where there's going to be a good defense, you need to think about what tort you can bring that might let the case as a whole survive. So some common state court defenses to look for, to be aware of, are the Illinois Tort Immunity Act. So the Illinois Tort Immunity Act is a big one. It's kind of similar to qualified immunity, but this one is statutory. It says a police officer is not liable for his act or omission in the execution or enforcement of any law unless such act or omission constitutes willful and wanton conduct. So what that means is you cannot and should not sue police officers for negligence or accidents. So, if you were to plead a case under the traditional negligence standard and say, the police were negligent in investigating this crime, or negligent in looking for other suspects, you can't do that. Your case is going to get tossed out. The defendant is going to move to dismiss based on the Illinois Tort Immunity Act. So as a matter of pleading, you have to prove willful and wanton conduct by the police officers. So the next thing, which I've kind of been alluding to throughout, is whether to file state and or federal claims. So the things to think about are federal claims carry attorney's fees. So under Section 1983, actually Section 1988, if you win, your plaintiff's attorney's fees are paid by the other side. So if you go to trial and win as a plaintiff, you get your attorney's fees paid by the other side. There are, lots of litigation over attorney's fees then, what attorney's fees are due. But that can make a federal claim more valuable, obviously. Why some people go to state court instead is juries and judges. So you have, what you want to think about is if I were to file this in state court instead of the federal court, would I get a better jury for this plaintiff? Would I probably get better judges for this plaintiff? And this is always changing. And I think it depends on the plaintiff you have as well. So you want to think about who is my plaintiff and who would identify with them and where am I most likely to find the person that identifies with them. In Chicago, I would say among practitioners, there is an increasing trend to file in state court instead of federal. We still file cases in federal, but sometimes we file them in state instead. But I would say there is an increasing trend towards state court cases only. If you have or want only state law claims, you have to file in the county where the incident happened or where the officer resides. You can file in either one. If you have federal claims, you can file in either federal or in state. But if you file in state, the defendant can remove the case to federal court. And so that's something to think about from the beginning. So some people might say, well, I'm going to file in state court with my federal claims. Well, if you do that, the defendant can remove to federal court, and they likely will, which tells you something. If defendants prefer to be in federal court, where should plaintiffs prefer to be? The next major question, once you know where you're going to file, is when do I file? And actually, when do I file could have been at the beginning of this presentation, and maybe it should be. The question of when a case has to be filed by, most practitioners know, is the most important thing that you find out as soon as you can find it out. So in your, when you're talking to a person thinking about filing a 1983 case for them or a state court case for them, the very first question, needs to be, when did this happen? And then all the other relevant dates. So when did the arrest happen? Were you prosecuted? When did it end? Did it totally end then, or was one charge thrown out? When did you have trial? When did the appeal happen? We've had cases where, the important question is when the appellate court decided to overturn a conviction. And, it can be kind of hard to find that out, actually. There's the date that they issued their opinion, but then sometimes people don't go out and get out for several weeks thereafter. So you want to get all these dates, from the very beginning. You obviously want to check your statute of limitations for your particular claim. Statutes of limitation is what that should say, can be as short as 6 months to file a tort claim against a federal officer, or as long as 2 years, a federal false arrest claim. So from the very beginning, you want to get your dates, get your statutes of limitations, all that might be considered, and file within the shortest one. But a complication is that you can also file too soon, meaning before all the conditions precedent to a claim have been met. So for example, before a favorable termination of the criminal case, a person might call you the day after they're arrested and they're currently facing charges, and those charges are pending. There are practical reasons why you wouldn't want to file a lawsuit yet. Maybe you don't want to rock the boat. Maybe you don't want to, alert the city or the state's attorney's office that you're going to do this. Sometimes it can make them prosecute the case more aggressively. Whereas if you didn't file, you didn't, let them know that you were there, maybe they would let the person go. The officer doesn't show up, they dismiss the case. So there can be strategic reasons for waiting, but there's also legal reasons for waiting. If you want to sue for malicious prosecution, for example, you have to prove that the criminal proceeding terminated in the plaintiff's favor. So you have to wait for that to happen. So usually you would want criminal charges to be resolved before civil claims are filed, but you cannot blow a statute of limitations. So what do? Well, what if it's both too soon, but you don't want it to be too late? You can file a civil case and just request a stay until the criminal case resolves. So if you have any question at all about filing on time, making sure you do it fast enough, you can go ahead and file. And then you can basically acknowledge to the court that the case isn't ready to be litigated, but that you wanted to file it to preserve your statute of limitations. I've seen that done. I think I've done that, and it works. We've never had any issue with that. Okay, so we've covered who gets to file, who do you file against, what are you suing for, where are you doing it, and when are you doing it, and now you actually are in the litigation. I didn't get into detail here. What I left out is the defendant answering. So after you file the case, the defendant is either going to answer or move to dismiss using one of those defenses that I spoke about earlier. But once your case is going, these are the discovery basics. So the things that you're going to have to do in a case are initial disclosures of evidence and witnesses. So in federal court, there's a couple different rules about this. One is Rule 26, the other one is the MIDP. And what it means in federal court, though, is you have to share with the other side immediately what your evidence is. So depending on whether it's Rule 26 or MIDP, you basically have to give a list of who you intend to call at trial and what evidence you will use. When I was a younger lawyer, I didn't pay so much attention to this. I would do it, but maybe I didn't consider it as important as something that happened later on. Now I've learned that it's incredibly important to come out of the gate very strong. So to start the case by presenting to the defendant right away from the beginning how strong your case is, it really sets the tone for the litigation. From there, once you have the disclosures from the defendant, you can issue interrogatories, just means questions. I don't like to do stock interrogatories at all. Maybe earlier in my career and when I worked for other people, we did some of these. I understand why people do them, it saves time, but I think the better way to do it is to make them very specific to your case and to make them very straightforward. I'd like to avoid legalese with interrogatories because the person answering them, yeah, their lawyer will be typing it and maybe even answering for them, but you want it to be a question that's easy to understand so that the answer is easy to understand so that they can't pretend they didn't understand it. So I like to say things like, why did you arrest John Smith on March 16th? make them answer that very simple question. Why did you put him in a chokehold? Or who was there and saw you do it? I like to do those sorts of questions. With the request to produce documents and things, I would say that's different. It also should be tailored to your case, very specific to what's going on. But if you can, you want to get sample discovery requests from experienced practitioners because there are things you might not know to ask for. So police documents that experienced practitioners know exist that other people, don't necessarily know about. An example of that that's kind of interesting in the Chicago police context is how do you get police officer complaint records? And it's changed over time. There's been various organizations that supposedly investigate the Chicago police, but having the right words to know what to look for shows the defendant that you know what you're doing, and that if they don't give you what they should give you, that you will know. And also, sometimes the defense attorney is inexperienced and they don't know to look for it either. So it's not always malicious on their part if they don't give you something that they're supposed to. From there, you'll do oral depositions, and that's sworn testimony under oath. We like to do those videotaped whenever we can. Another discovery tool is a request to permit entry onto land or inspect evidence. We use this whenever we can and whenever we need to. So, for example, if someone's assaulted at a police lockup, we request to go see the lockup. We want to see the whole thing. So we'll send a request to permit entry into the police station. And of course, they put some, rules around it, when we can do it, what we can do, but we take photos, we take video. And number one, you can get some good evidence that way. But number two, it just gives you a better understanding of what happened. So PI attorneys and all sorts of lawyers will tell you, you want to visit the scene. And this is an example of visiting the scene, but I think some people wouldn't think that you could do that, but you can. The federal rules at least allow for it. And inspecting evidence, there might be some evidence that supposedly was your client's, for example, a gun that he supposedly dropped on the street. You can request to inspect that gun, go and take pictures of it. Also, requests to admit can be useful. You can send these early in discovery sometimes if there's something that you just want to get out of the way, like admit that you did not have a search warrant to enter the home. You might want to send that early in discovery, whereas other sorts of requests to admit you would want to use at the end. Once you have a better idea of everything and you've isolated some issues that you want to get the defendant to admit based on everything that everybody has seen. And then the final tool is a 30B6 deposition of a city representative. So if you can use, you address these to the organization, the attorney for the organization, and this is you telling them, I want someone to testify on a topic. So you tell the city, please designate a person to testify next Thursday about your policies for giving nebulizer treatments in police lockup. And then the city has to figure out who can give that testimony. And this is a really powerful tool because you don't want to guess. The other option is you try to figure out who would give that testimony. You depose them, spending money doing it, and they don't actually know the answer. A 30B6 puts the onus on the city or the organization to designate who has the information. And then if they show up and you're deposing them and they really don't have the answer, they're going to be in trouble, because that was what they had to do under 30B6. So once you've completed discovery, the next thing that you're going to face are motions for summary judgment. So in federal court, these are almost a certainty. If you don't know, a motion for summary judgment is a motion by the defendant where they say there is no genuine dispute as to any material fact, and the movant, the defendant, is entitled to judgment as a matter of law. So I'm saying defendant, but we've actually used summary judgment as a plaintiff before. Where someone gets arrested and the police officers basically admit why they did it, and they give their version of events, and sometimes even under their version of events there was no right to arrest. So in that sort of situation, a plaintiff can move for summary judgment and say, look, even under the defendant's version of what happened here, there was no probable cause to arrest. So that can be kind of fun to do if you can do it. But again, defendants are going to file these in probably every single case. I can't think of a case where they haven't done it. They're common in state court too, maybe a little bit less common. Again, another reason to think about federal versus state. The rules for summary judgment motion practice are very specific and difficult. So this is an area of litigation where if you haven't done it before, you need to find somebody who has and have them help you through it. The rules come from Rule 56, but they also come from local rules. So from the Northern District of Illinois, they have specific rules and guidelines. And then your individual judge is going to have their own rules too. So there might be rules about when summary judgment can be filed. You know, maybe the defendant has to confer with the plaintiff in writing first. But then there's just very strict rules about responding to these motions. There are very detailed fact statements where if you mess it up, if you don't do it right, all the facts that the defendant alleged are deemed admitted. Which is obviously a big problem because in these motions for summary judgment, often defendants, I mean, kind of sometimes full-blown lie about what the evidence showed. I've seen that before. Or leave out, you know, statements that a person made in a deposition. So they can be very difficult to respond to. So again, if you've never done one before, you know, see if you can get other people to give you examples of Rule 56 summary judgment filings. So finally, trial. This could be its own CLE, obviously, how to conduct a 1983 trial or a state court trial. But, you know, some things to think about are federal court has very specific rules for pretrial procedure. You need to check the Northern District of Illinois' general orders and also your judge's standing orders, similar to summary judgment. The procedure is very prescribed in federal court. So I know that some people don't like it because they say it's, you know, too strict or too, requires too much of you or something like that. I like it, but I'm the sort of person that likes, you know, order and advance notice of things. So there's, you know, a form that's on the website, you can find it, and, you know, you have to do a very detailed pretrial order that's then submitted to the judge well before trial. And so lots of things are ruled on there. You do exhibit lists, and even those things are ruled on. So right there in court, you know, before any jury's been impaneled, you're in front of the judge talking about various pieces of evidence and what should come in and what shouldn't. And in general, what can happen is if you don't object then, you know, some courts might say you lose the right to object. I don't really think that's true. You can and always should maintain your record with an objection, but that's what the pretrial order says, you know, is that if you don't object, if you don't lay a basis for why you're objecting, that it's going to come in, the jury's going to see it. So that pretrial procedure in federal court is, you know, very detailed. Again, this is where you want to work with an experienced practitioner to at least see some examples of pretrial orders that have been filed. Make sure you're doing it right. But what each judge requires is specific to the judge. State court is much more wild, is how I would describe it. You know, with state court trials, number one, you don't even know who your judge is, you know, until you show up and get assigned. And my understanding is in state court, you do your motions in limine the same day, you know, just a matter of minutes or hours before the jury is being impaneled. In federal court, you do your motions in limine usually months before trial, if not weeks. In state court, it's more rushed. It's more right then and there. And so finally, again, ending with maybe where we could have started, you know, what are we suing over? So I had mentioned that you're suing for money damages. You know, that's what a 1983 suit is, and that's what a tort suit is too, suing for money damages. And so what can you recover? So if a plaintiff wins, they can get compensatory damages. So that means, you know, if they can prove actual loss, so maybe they lost their job, and you can get compensation for lost wages. Maybe they had their car taken when their car shouldn't have been taken. Well, what was the value of the car that was taken? Maybe you have destroyed property in a wrongful search of the home case or in a vehicle. You can have we call them hard costs like that, but also you can get money for emotional distress. So this is, you know, hard to quantify. And a lot of clients, you know, might ask you what they can expect, you know, what's the average award, what's the average settlement. One way I think to think about that is the city of Chicago has a rule where they won't settle any case above, or can't settle any case above 100,000 without city council approval. So, you know, you might see a lot of 1983 cases settling beneath that amount. Because as we all know, that's, you know, political at that point, whether city council is going to approve something. In addition to compensatory damages, what you can also sue for are punitive damages and attorney's fees. Now, theoretically, punitive damages are supposed to be paid by the individual officer. That is supposedly how it works, but they don't actually. So one study found that the officers in her study never satisfied a punitive damages award and contributed to judgments in just 0.44% of the 8,600 civil rights settlements and judgments to plaintiffs that she researched, and their contributions amounted to a mere 0.02% of the $760 million that states, cities, and counties paid out in these cases. So we sometimes think about these cases as being against individual officers, making an individual officer answer for what he or she did. But do they do that? And I think it's a big question whether they actually do. You know, if the entity paying is almost always the municipality and almost never the police officer, I think there's a big question about that. The result of a plaintiff loses is that they have to pay the defendant's costs of suit, which can be thousands of dollars. So a plaintiff actually bears a greater risk in these lawsuits than police do. If a person brings a lawsuit and they lose, they're going to owe out of their pocket several $1,000s. And most victims of police brutality are poor, almost all of them, with very few exceptions. So it can be risky for an individual person to sue a police officer. Whereas, when a police officer loses, he faces virtually nothing. He certainly is not going to be terminated. He probably won't have to pay anything at all, and his life moves on. So that is the end of my materials. What I'm going to do now is check and see if we have questions and go from there. Okay, so, sorry, it took me a second to find where those questions were. Okay, so I see that someone had asked what materials I was referring to. Those were emailed out by Dan sorry, Dan, I don't know how to pronounce your name, Masaglia. Okay. Someone asked, are there any federal non-constitutional claims cognizable under 1983? That's a good question. And yes, the answer is yes, there are. I had thought about including some of those in this presentation, but I didn't think we would have time. One area is the ADA. So that's one that's I would say kind of new in terms of it being applied to police officers. So, what this can look like is, for example, a person who's out on the street or on a city bus, suffering from a schizophrenic episode, and, they're disruptive and they're bothering everybody, and the police officers are called. If the police officers act unreasonably in that situation, and maybe it's very clear that the person's having a mental health episode, but despite that, they throw the person on the ground and use excessive force. You can sue for excessive force, but you can also sue under the ADA and basically say that this is a denial of their rights as a person with disabilities. Another way where you can see it is in lockup. So with, for example, someone goes into lockup and they need a wheelchair to get around, and maybe the police officers take it from them and make them go into a cell without it. Where that's a denial of their rights as a person with disabilities. So the answer is yes. There can be other areas of rights that you can sue for using 1983. And then this person asked, what is the basis for bringing 1983 claims in state courts? Well, state courts are courts of general jurisdiction. So that means you can file any sort of case you want in state court. And so if you want to, you can file 1983 claims in state court as well. You have the right to, because you can file anything in state court. It's federal court that's more limited. Federal courts are courts of limited jurisdiction. The next question was, do the statutes of limitations toll from the date of the alleged tort or the date of discovering names of individual cop defendants? That's a good question, and one that I'm not really going to answer because I think it's too specific. it requires a little bit more research. So statutes of limitations, my understanding is that your not knowing an officer's name is not going to toll the statute of limitations. That's my understanding. So for that reason, if an arrest happened, some time ago and the statute seems like it's running, you want to sue, you want to try to find the identities right away, but if you can't, you want to sue the municipality if you still have time, because my understanding is not knowing an officer's name is not going to toll any sort of statute against him, and discovery I don't think is going to matter. The next question is, once a case is dismissed for qualified immunity, if the exact same fact pattern happens again, do the police still use qualified immunity as a defense? This is a really great question. So when courts are analyzing whether an officer is entitled to qualified immunity, they are supposed to do two things. One, determine if it's a constitutional violation, and two, determine if that right was clearly established, right? And so I would say that the court should do number one and then number two. They should decide if this violates the Constitution or not, and then decide if it was clearly established. So, they can say, we're going to analyze this. This was a constitutional violation. But number two, it was not clearly established. So this guy gets off the hook. Because then, yeah, that's what happens the next time, is that the next person comes along and that court has already said that's a constitutional violation. And now this guy number two, gets in trouble because now it's clearly established. However, what you see courts do repeatedly is they do number two and they don't do number one. They say, well, look, all that matters is whether this was clearly established at the time. So we're just going to move straight to number two. And the question is, was it clearly established? And no, it was not. So the case is over. And you're right to be concerned about that and think, well, then at what point can a person sue for something like this? It's a very big concern. It's a very real problem when courts do it that way. Okay, you said, what was the result of the case involving the police officer forwarding himself nude photos of the young lady? Well, we settled the case. What happened was we filed the lawsuit in federal court. Judge Holderman dismissed it. We took it up on appeal. So we appealed to the Seventh Circuit. Our option was also going to be to then file it in state court, like I said, for that tort. So we could have just filed it in state court, but we had kind of both things happening, appealing it at the Seventh Circuit and then getting ready to file it in state court, and we settled it. I mean, so that's what happened in this case. I think, yeah, I'll just leave it at that. That's what happened. Someone asked, you've mentioned suing for willful conduct, but not for negligent conduct. What about reckless conduct? So if we're talking about a state court case, the phrase that the courts want to use is willful and wanton. And it's not the courts, that's what's in the statute. So the statute says you can only sue police officers for willful and wanton conduct. So I would just don't use the word reckless. I mean, I think there's some debate about whether reckless is enough or, but at the end of the day, you need to just use that legal phrase, willful and wanton, and then plead facts that support it, like how did the officer demonstrate that his behavior was willful? And you want to think about the why, so people might call and tell you, like, a police officer framed them or, arrested them when they knew that the person hadn't done it, whatever. You need to figure out the why, because the judge and jury are going to want to know, and you need it to prove willful and wanton. You need to figure out why this officer would do that. Is it racism? Is it, disregard for the person because they're poor and they live in a bad neighborhood? Is it some longstanding feud between the police and citizens, which happens all the time? Is it retribution for a statement that they made on Facebook the day before? Okay, implicating the First Amendment there. So I guess that's my advice, is just use the phrase that's in the statute and don't plead reckless. I think you might just get yourself in trouble. Someone asked, is the statute of limitations for a claim that might be heck barred told during the pendency of a direct appeal or habeas petition? The answer is no, depending on the cause of action. So for false arrest, for example, if someone was arrested, many years ago and they've been in prison ever since, and you now want to sue for false arrest 4 years later, you can't. But it's a little bit more complicated because there's other things you could sue for. Like I had mentioned unreasonable seizure, continuing detention, 14th Amendment manual violations. Those, the clock doesn't even start to run probably until the case terminates in the person's favor. But there's a lot of complexity to that, to the manual type cases. I can't read this whole one. How do you deal with protective orders regarding taking photos in a police station? Okay, so we have dealt with that. We've also dealt with photos inside of a jail, which is outside the context of today, but photos of a police station. So, depending on who you're dealing with on the defense side, some defendants attorneys are going to be real hyper about, the photos you take inside a police station. I think that's kind of silly and overwrought, but you kind of need to play along with that game sometimes. So if they act like it's very, sacrosanct what the police lockup looks like, play along. I mean, give them the assurances that they want. And, you need to abide by it, because a protective order is when the court has said, certain things in this litigation are going to be confidential and you have to keep them that way. So, the judge has signed that, and it's a really big deal if you violate it. So you have to be careful, so if you take photos in this police station, you have to treat them with a lot of care. Don't leave them laying around. Don't, keep them on a public server, a public website. You do have to be careful with that stuff, because you can get yourself in trouble. And then someone asked, isn't the biggest concern for summary judgment motion qualified immunity? Yes. 100%. So, summary judgment motions often are going to be based on qualified immunity. And so that the defendant is going to be saying, even if everything you're saying is true, there's no clearly established law that this was illegal. And so, the plaintiff cannot recover. Somebody asked, how often do you see plaintiffs being required to pay litigation costs? Definitely, if they lose. So we've lost a couple federal civil rights cases, myself and when I worked for someone else, and 100% the municipality is going to try to collect that. So I've never seen a defendant not try to pursue it, actually. Any defendant that gets so far as to really beat the plaintiff, they're going to try to recover their costs. I think there are some exceptions, but now I'm kind of thinking a little bit more about employment law. But in the context of police, 100%. They will do that. And they can get their costs too if they win summary judgment. So whether it's by summary judgment or trial, if the defendant wins, they get their, or they can try to get their costs paid by the losing plaintiff. Somebody asked, what are your favorite types of cases to handle and why? My favorite cases are home invasion cases. Number one, because the law is good. So, the law protects the person's right in their home. There's a lot of, strong case law about that. And also just as a practical matter, I think that it's a right that needs to be, protected, or we're in major trouble. If we get to the point where police officers are allowed to come in people's homes without a warrant or consent or emergency, we're in big trouble. And so that's why those cases, even if they're not high value, I think they're incredibly important. I have one I'm considering taking right now where nothing in particular happened to the person. Her stuff wasn't broken. She was only detained for 2 hours, but the police came into her house, and I think we may sue over it because those are my favorite kind of cases to handle. Someone asked, would you discuss the standard for punitive damages? My understanding of the standard for punitive damages in federal court is where I'll start, is that, and there's jury instructions on this. So if you just look up 7th Circuit jury instructions, they tell you when punitive damages should be awarded. But what those say are punitive damages should be awarded to punish the defendant and to deter the defendant and others like him from similar behavior. So if the jury wants to punish the defendant, they should award punitive damages. If the defendant wants to stop this guy from continuing to do that or to serve as an example to other police officers, punitive damages should be awarded if they want to do either of those things. So that's when you can ask for, or when you can get punitive damages. In federal court, the idea of getting punitive damages is pretty much routine. So like on a verdict form, there's going to be a line for compensatory damages and a line for punitive damages, and there's very little fight about that, including it. State court is different. You know, in state court, there is a statute that says you cannot plead, you cannot ask for punitive damages in a negligence case unless you've gotten leave to do so. And so there's a lot of misconception that that should also be applied to intentional torts. That's wrong. You know, it's not true. The statute only applies to negligence cases. But because state court judges are so used to dealing with negligence cases, they might say, well, how'd you plead punitives? You didn't ask me first, but you don't actually have to. So I hope that answered the question there. Somebody asked whether the $100,000 cap, or, you know, whether a case can be settled without city council approval is just for compensatory damages. Well, the answer there is that police officers never pay punitive damages. So punitive damages are not paid by police officers, and so they don't settle for punitive damages either. I guess that's kind of the question. So if a case settles, there is never going to be an amount included where the defendants pay an amount of money. Now, that being said, maybe there's some plaintiffs' attorneys who ask for that and who have gotten it. I don't know. I've never seen that done. The next question is, what type of screening do plaintiffs' attorneys do when deciding whether or not to take a case? What would you consider a good case? Can you file in state and fed? This is a great question. So what type of screening do you do? So you want to really know who your plaintiff is. You need to know them inside and out. So you want to meet them in person and talk to them about what happened, obviously. You know, that's where you start. But then you have to figure out if what they're telling you is the truth. Can you figure out if it's the truth or not? You know, so for example, like, okay, this happened to you. Have you talked to your wife about this? Can I talk to her? Okay, maybe he's not married. Okay, mom, sister, whatever. It's super important, I think, to talk to the people in the lives of the potential plaintiff to get their version of it. You know, not that it's admissible. It wouldn't be admissible, but it just gives you flavor and context for whether the person's telling the truth. So I really like to do that. And people are usually happy to let you. If they're reticent to let you, to me, that's a red flag. So you fully vet your person. You also vet them on social media. So, you know, you check out, you Google them and you really study that, you know, you study what they're up to. Are they on Facebook? You know, maybe making gang signs. Are they on Facebook with stacks of money and guns? A lot of people do that. You know, whether it means they actually have stacks of money and real guns, I don't know. But those sorts of things, you know, a defendant will find. So you need to know about it first. I also do background checks on my plaintiffs most of the time. I have them tell me what their criminal background is, and then I also do a background check on them, like through a private investigator. And so you really fully vet your person to figure out if you can prove the case, if they have skeletons in their closet, if you're going to want to deal with them for the next 2 to 3 years. And then you also research your defendants. So, you know, as soon as you find out who the officers are, you look them up. There's publicly available websites now where you can see the number of complaints against a police officer. And so you can look there and see, you know, is this a repeat offender? Is this someone who, according to this website, has 70 complaints? Well, maybe I should sue him. You know, he probably did do this. Or sometimes you'll research a person and they don't have any complaints. They've never done anything wrong. Then you really have to ask yourself, you can still sue people like that. I've done it. But, you know, you might want to take a second look at, okay, this person's never been accused of misconduct before. You know, maybe they're just new, or, you know, what happened in this instance? So we look at that, and then obviously you look at the case law too. I mean, that's kind of obvious, but you know, you look at, can I prove my case? And so that's kind of the whole analysis that you do. And then can you file in state and federal? That's a really great question. I know lawyers that do. There are, I won't out him because I don't know if he wants me to out him, but I know a lawyer who has advocated for that, an experienced lawyer who has advocated for filing a case in federal court and filing a case in state court. I think you can. You don't plead the exact same thing, but you can plead parallel things. So you plead in federal court, you know, false arrest and excessive force, and then you plead in state court battery and, you know, I think you can do it. I've never done it, but I think you can. Somebody asked, how do you get the city of Chicago to pay an officer's punitive damages? I don't think you can. My understanding is that state law says that they cannot do it. So I don't know of any good way to do that. Somebody asked about ADA in prisons. I was told to stay away from a prison discussion today just because it is so different, but you know, I can answer it because we have a few more minutes left. ADA in prisons are a big deal. We have filed over ADA denial in prison. It's a rich source of litigation, I would say. Prison litigation is very difficult for other reasons. The Prison Litigation Reform Act, having access to your client, you know, there's lots of things about prison litigation that make it difficult, but you can absolutely use the ADA to recover for people in prisons. Somebody asked, how do you deal with pushback regarding a request to produce? Well, what I do is we send a request to produce. I like to send those without legalese, like I said, with regard to interrogatories. So I want to make those very simple. So like, send me all reports related to this. Send me all reports related to my client on this date. Send me all videos that you have of my client, no date limitation. Send me all audio you have of my client's voice, no date limitation. So we like to make them, you know, succinct, easy to understand. So then what the defendants answer, and they put a bunch of objections in and maybe give you something or don't, I like to follow that up with a letter that says, you know, as a reminder, you have duties to respond to discovery without all this BS. I don't say it exactly like that. You know, please answer these properly. If they continue not to do so, you schedule a call, you argue about it, then you maybe send another letter. And then finally, you would have to file a motion to compel if they don't give you what you want. An important thing to think about with request to produce is sometimes it can be more time effective to just depose the person, you know, and just make them answer the question face to face. So, you know, bring them in, depose them and ask them, you know, did you take any video of my client? Well, no, I didn't. Does any video exist? Well, I wouldn't be the one who knows. Well, who would know? Well, I guess, you know, the guy who runs our station, I guess our commander. Okay, well, what's his name? You know, sometimes depositions are just a much better way to get this stuff than request to produce, because, you know, there's the lawyer in the way. When it comes to fights over request to produce, you know, the attorney gets to give the answer and make all these arguments. Sometimes it's better to just get a person face to face. When it comes to like police department records, this would be a great time to send a 30B6 notice to talk to like a higher up in that police station, for example, about, you know, what exists, you know, where do you have video in your police station, you know, to get to the bottom of whether some of these things exist and have been withheld from you. The next question is, does a municipality have to indemnify an officer for a state law battery claim? Yes, most likely. So under state law, a city or county, a municipality does have to indemnify their employees for damages that they have incurred in the course of their duties. Once in a while, municipalities will not do it. And that happened, you know, has happened in cases where the police officer has been cut loose. He's been fired because he's so bad. It's not very common, especially here in the city, but in the suburbs, you see that sometimes where one example was in Schaumburg. A few officers were arrested and charged with, you know, like stealing money and drugs from arrestees. Once those people were fired, the city no longer paid for their defense. And so that signaled that they didn't intend to indemnify them. And then sometimes the Fraternal Order of Police will take over the defense. So that can be a tricky situation. Like if the behavior was actually really so bad, sometimes the city will say they're not going to indemnify. And then you're in pretty big trouble, you know, if the city doesn't indemnify and you're just trying to recover from an individual. Okay. Someone asked, do you ever do press releases or otherwise engage the media in connection with these types of lawsuits? What are the potential benefits and drawbacks of doing so? I do not generally talk to the press about my cases. That's just me personally. I've never liked to do it. I think with clients who are not sophisticated, which most victims of police misconduct are not sophisticated, meaning, you know, very highly educated people, people can get themselves in trouble. You know, when they speak to a reporter, people can get themselves in trouble. So I've done it. If you Google me, you can find that I've done it. I don't really like to do it. And I think that's a personal preference. And it is up to the client as well. So, I mean, you always want to find out if the client wants you to do it. Once in a while, the client will. Most of the time, or not most of the time, but often they don't. You know, often they don't want to. So that should be a collaborative conversation between you and the client, in my opinion. Someone asked if Monell claims are common in 1983 litigation. Yes, they are common. They're hard to win. I mean, there have been some fairly recent high-profile wins under Monell. You know, a variety of attorneys here in the city have proven that the city of Chicago has policies that violate the Constitution. So, but they're difficult, they're expensive. And so I think that they're not always included in a case, nor should they always be included, but yeah, they certainly are common. Someone asked me to estimate a range of defense costs. So that's like if you lose, what you have to pay. What I've seen is like $3,000. It's in the thousands. It's basically like what they had to pay court reporters and things like that. So it's not astronomical, but for a poor person, you know, it's a lot of money. Someone asked if I've seen police departments improve their practices as a result of these suits. It's hard to say. I know that in some of the cases we have asked for changes, you know, so we've had some cases involving, you know, like withdrawal or drug addiction in lockup. That's kind of getting into jail and police. But with those, there have been times where we have asked for some sort of change, like change your protocol with regard to this. And we have gotten that agreed to in settlement agreements. You know, but just thinking of the city of Chicago, I think the unfortunate answer is no. I don't see behavior change as a result of these lawsuits very often. But I also don't really know. You know, I don't work in the police department. I don't really know. But from what I've seen, I think the answer is not that often. Someone asked if under the Illinois Tort Immunity Act, is bringing suit for grossly negligent police conduct also barred? Again, similar to the reckless question, there's just no reason to use that language. I would not use that language. I would say that what they did was willful and wanton instead. And then someone asked, what is the public site available to search officer complaints? I will provide it. That's what I can say. And maybe what I can do is link to it on my website too, because I think that would be interesting. I don't know it offhand, but I will, I'll put it on my website. How about that? And maybe Dan can share it as well. I think this will be our final question because we're out of time. But are there claims that could be filed in either state or federal court where a police agency refuses or fails to make an arrest in which a person is a victim of a crime? The answer is no. You can't sue for the police refusing to arrest someone. The only exception is maybe like an equal protection claim. So, you know, based on like sex or race. So like maybe if, you know, a Black person alleges that they were beaten up by a white person for no reason and the officers just like choose not to do anything about it, you might be able to make an equal protection claim there, but I think it would be an uphill battle because there's so much case law and statutes out there that say you can't sue police officers for failing to do things. You know, it's kind of, again, you can't sue them for negligence. Okay, so our time is up. I want to thank everybody for listening today. I hope you learned a little bit about 1983 litigation, also the state law similar litigation. And if you have any follow-up questions, you can feel free to call me or email me. All my contact information is on my website, www.julieherreralaw.com, and I'd be happy to answer any questions that I can. I want to thank the organizations who put this on for having me. And that's the end of our presentation. Thank you.